And now I invite everybody to start off session 1, which will continue until 1 p.m. And the first session will be dedicated to tax conflict and tax dispute, uh, correlation of concepts and consequences. Before we go down to the reports and presentations prepared by the speakers, I would want to inform you that we have prepared a compilation of opinions of the Cassation Administrative Court of Ukraine, which will become available right after the conference. Let me remind you that the deadline for your interventions is 15 minutes. When the time will is over, I will show you the red card. If the air alert is announced, those of you who can continue delivering speeches are kindly invited to do so. For those who feel uncomfortable, please let us know, and we will continue working on the agenda. Now we are going down to the core of our discussion, and I invite Mikhailo Smokovich, judge, president of the Administrative Cassation Court within the Supreme Court, associate professor, who will deliver a speech, tax disputes, challenges of administrative proceedings. Let me remind about the time limit of up to 15 minutes. Thank you, Raisa. So taxes is important part of, and taxation regime is an important part of functioning of any state. Benjamin Franklin, who is considered to be one of founding fathers of the United States of America, used to say that nothing is sure in this life except for death and taxes. Taxation is taxation assessment and taxation enforcement is a complicated thing. Taxpayers can challenge tax assessments and tax enforcement. So we can state that the tax disputes will always exist until taxes are collected by the state. Ukraine's constitution, Article 67, says that everyone is obliged to pay taxes and levies in accordance with the procedure and the extent established by law. In Ukraine, such law is the Tax Code of Ukraine, dated December 2, 2010. The rules of the taxation, the tax code of Ukraine make give more details on the constitutional norms in the area of tax relations. Solving tax disputes is attributed to administrative courts, which requires from us, judges of administrative jurisdiction, deep knowledge of not only tax law, but also customs, financial, and other branches of law, which is necessary for proper and stable protection of rights and freedoms and interests of taxpayers. Ukraine's tax system is of quite a changing nature. The tax code of Ukraine was adopted in 2010. It took legal force on the 1st of January 2011. But since then, some 170 laws introduced amendments, multiple amendments to this code. The legal consequence of multiple changes adopted to the tax code of Ukraine implied various approaches to the resolution of similar issues at times. Besides, this year, the war intervened and it has had a heavy impact on the country because the modern wars, it's not only about military opposition, it's not only about military conflict, but it is also about economic and diplomatic opposition, as well as opposition in many other areas.
It was expected that, first of all, we will reduce the tax rate, and we thought that we would cancel the military church and social security payment. Second point, we will totally not have the taxation at all. But now, in military situation, we are working in a very different direction. So now we are thinking if it is possible to prevent it, and if yes, how? First of all, the tax policy must be balanced. The legislator should be responsible and he should determine the tax policy of his state, and it must be to stimulate economic growth of enterprises in Ukraine. At the same time, tax legislation should have higher level of stability. The taxpayer has the right to expect the principle of legal certainty and balanced interest. Second of all, the legislature, when introducing changes and amendments, and first of all, it's necessary to prevent the due legislation. Second of all, to have and prevent the violations of rights, and also to have the fact that the authority must be able to implement their policies. Third point, it is important step in this process to have constructive interactions of institutions. Thus, Cassation Administrative Court works with the policy, and we received 68 draft laws, and 45 of them the court drafted proposals and amendments. It mostly had to do with the Code of Administrative and the respective changes, but neither of them had nothing to do with taxes. Although in 2021, the Parliament adopted 12 laws that introduced amendments and changes to the tax code of Ukraine. Mainly in this aspect, it is good to have at least a cooperation with the Rada Committee on different aspects. And it, first of all, helps to have second aspect of this address has to do with the quality of legislation. The European Court of Human Rights has repeatedly mentioned that no unjust intrusion can be done with the rights of particular the rights of a taxpayer. And the case versus Ukraine, it was mentioned that first of all, the national legislation has different obligations, and in such situations, national bodies were under an obligation to use an approach that would be most favorable to taxpayer. However, the bodies have respective extra charges on paying the tax. This approach means nothing else than just intrusion with property rights of the European Court of Human Rights said that if there are collisions in tax relations as a result of that, at their own discretion, authorities have different approaches to this. In the opinion of the school, the fact that there is no procedure that would have an important financial instrument violates the requirement of respective convention. Tax legislation is now codified, thanks to which we can minimize tax rules. In paragraphs 1 and 11 of the opinion of 2008, the consultative Court of European Judges and the Committee of mentioned that the quality of judgments depends not only on the judge but on many factors that are external to the process of quality of legislation, number, quality of judgments can depend on imprecise conditions and on defects of procedural legislation. We can analyze in different ways, in particular, we need to make sure that there is respective definitions. It means that analysis
тлумачити право, слід пам'ятати також і про обов'язок судді сприяти правовій визначеності. Правова визначеність гарантує передбачуваність змісту та застосування юридичних норм, сприяючи тим самим забезпеченню високої якості функціонування судової системи. Який урок ми, судді адміністративних судів, маємо винести із наведеного вище? Думаю, вони мають бути такими. Перше. Суд, вирішуючи той чи інший спір, зобов'язаний переконатися в тому, що спосіб, у який тлумачиться і застосовується національне законодавство, зумовлює такі правові наслідки, які є сумісними із принципами верховенства права і законності, визначеними і гарантованими Конституцією і законом.
Fundamental rights the question of legislation together with recognized principles application is an obligation of national bodies. And third, the decision must be duly substantiated
для інших суддів при розгляді і вирішенні ними судових справ, зокрема і у сфері податкових відносин. Наступний, третій важливий аспект доповіді стосується усталення.
Another third aspect of my report concerns the stability of jurisprudence in the area of uncertainty of jurisprudence in the area of tax dispute resolutions. In the meantime, we cannot but take into consideration that changing nature of a tax regulation may have a certain influence on how tax how justice is administered in tax disputes. Besides, nobody can object, I guess, that the stability of jurisprudence of judicial practice is an indirect correlation with the stability of legislation. So in order to make sure that judicial practice is uniform, stable, the legislator needs to make sure that the substantive and procedural laws are stable. Despite all challenges and complications relating to the change in nature of the tax legislation, I'm sure that legal that judicial practice and jurisprudence in administrative disputes should be harmonized, and this is what the cassation administrative court and the Supreme Court shall aim at as ultimate goal of their operation. Let me terminate my intervention with a quote by Charles-Louis Montesquieu, who used to say that nothing requires from the state as much wisdom and prudence as imposition of taxes. Indeed, I think we cannot but agree with this saying. I have to finish my presentation here because of the time limit, but my report is available in full in writing. Thank you, Raisa. Indeed, the constant amending of changing legislation may affect the stability of judicial practice and jurisprudence. Despite that, I guess that the Cassation Administrative Court of Ukraine is succeeding to a certain extent to come up with legal opinions which bring in some stability and legal certainty. Now we proceed with our next speaker, Mr. Mykola Kucheravenko, first Vice Rector of the Yaroslav Mudry National Law University, academician of the National Academy of Legal Sciences of Ukraine, PhD in economics, professor and member of the Scientific Advisory Board at the Supreme Court. Mr. Kucheravenko will develop on the issue of the nature of tax in the context of resolving tax conflict. Thank you. The floor goes to you, Mr. Kucheravenko. Thank you, esteemed Raisa. Let me start as usually. Let me welcome and congratulate all the participants on the occasion of the conference. I fully agree with Raisa mentioning that we continue working working hard despite bombs and shelling that continue taking place all over the country, but in particular in the city of Kharkiv. Just this morning, we had two explosions in the suburbs of Kharkiv. One of the bombs damaged a secondary school. Despite all this, we are doing our best to continue operating as usual. And I think it's one of the strategies to preserve one's mental health and to remain on the track, on the usual track. Let me now go down to the core on my discussion, and I will start with an unusual and unpopular statement, maybe. I guess that in the nearest future, we may expect the complications in the resolution of tax disputes. Because of wartime, because of the existing circumstances, because tax disputes are different from disputes in criminal jurisdiction. For example, murderers, burglars are tried and prosecuted in the same manner despite circumstances, because murders and burglaries and other criminally punished deeds remain so under any circumstances. While when it comes to tax regulation, when it comes to tax disputes, it is a very sophisticated area compared to criminal law, for example, because when adopting any amendments to tax legislation, we need to take into account a number of factors, and this number even increases when it comes to complicated circumstances, such as martial law, such as active hostilities. Besides, we will need to train young lawyers when respective amendments take effect, which is another important and complicated area of intervention. As of today, tax and tax obligation, these two phenomena should be seen from a different angle, considering the situation in Ukraine. One of the previous speakers, Mr. Smokovich, I guess, made reference to Article 67 of the Constitution of Ukraine, which obliges a tax payer to submit, to report before tax authorities. It should mean that the tax authorities should also have some obligations before the taxpayer. It would be fair This is where we see the balance of interest, because otherwise only one party to legal relations has obligations and duties, while another one doesn't have anything. I'm sorry for mixing up together theory in practice, but this is how I see my today's intervention. Let us now talk about the Ukraine's tax legislation. We used to have clear definitions of what is a tax, what is a duty, what is a levy. Now it's different if you look at Article 6 of respective legislation. We used to have a clear delineation between the right of the taxpayer to declare and report and the obligation of a tax authority to exercise control and oversee. Now the situation is a bit different. The wording of the legislation changed. To put it simple, today when it comes, for example, to an enterprise of critical infrastructure, the law says us that the taxpayers' compliance with obligation to report, to explain and to pay taxes is in direct correlation with the tax authorities' possibility to ensure proper control and oversight. In the meantime, we cannot but state that the critical infrastructure are often in very complicated, find themselves in very complicated financial situations because if it comes to utilities, enterprises, individuals tend not to pay for utilities, which means that the critical infrastructure enterprise does not receive all the amounts due, which leads to a situation where the enterprise is just unable to pay taxes, to properly report and to take places, to properly report and pay taxes. It is just impossible because the state has not enforced, failed to enforce the citizens to pay for utilities, which is the source of income for the mentioned enterprise. So here, we are not talking about the negligence of a critical infrastructure enterprise, but rather about the state's failure to create conditions for the taxpayer to comply with its tax obligations. Now, let us think all together. What is tax? If tax is just an amount paid by the taxpayer to the state, I think it would be too much simplified. because such a definition implies that we give money to a state or to a local self-government to be spent for anything they want. But it is not true. It is not this way. We pay taxes. By paying taxes, we give money to the state, to local self-governments, because we want them to spend this money for certain purposes. And this is a completely different situation. Thus, if the government or local self-government isn't able to comply with their obligation on spending money for the purposes the taxpayer expect them to spend this money for, then such a state or such a local self-government should not expect the taxpayer to comply in full and in time with their financial obligations, with their tax obligation. I'm trying to make my speech as much fitting the time limit as possible, because I'm very afraid of seeing a red card from Raisa. I don't want even seeing a yellow card, so I'm tracking time. So again, let me sum up my intervention. We all believe in victory and success of our country. However, we cannot but reject the fact that some challenges and some complications are still ahead. Thank you. Thank you very much. So indeed, for this very interesting intervention, and let me now quote something which I can see in your written report. You say that the disputes between the state and individuals will be minimized as soon as conditions are in place for both to comply with their obligations. We proceed with our work. I'm giving floor to Krzysztof Winiarski.
Dear ladies and gentlemen, thank you for inviting me and having me here. Ukrainian colleagues, it's very important to have due that good practice.
Michała Smokowicza, Hołowu Kasacyjnego Administratywnego Sudu u składu Верховного Суду Ukrainy, pana Daniło Hetmancewa, Hołowu Komitetu Верховної Rady Ukrainy, pani Nataliu Błażicku, Sudu Верховного Sudu, pani Edith Seller, Hołowu Europejskiej Asocjacji Administratywnych Sudów, pani Oksanu Cimbricku z projekta Prawo Justice та інших. Щиро сердечно вітаю і радий нашій зустрічі. Na poprzednich konferencjach, jak przedstawiła waszej uwadze problematykę, co stosowała się z okrema jawiska uniknienia opodatkowania, transfernych cen, ta pryncypy polskiego podatkowego prowadzenia. Сьогодні хочу розповісти про польські місцеві податки та збори. Останнім часом вони починають відігравати все більш важливу роль. Надходження
can finance the territorial and territorial governance. That's going to be in
Trivneva struktura terytorialnego podílu держави. W rezultacie reformy było sformułowano systemu terytorialnego podílu Polski, jaka składaje się z
have a system that is made up one with different municipalities and we have territorial units that have respective powers. It is important to see sources and to have a few steps to have in place delegate powers, to have the shares of PIT and CIT payable by the authorities. We have this in terms of subventions by the state. It should be mentioned that there are serious disproportions between the taxpayers and we have respectively the highest taxpayer is Warsaw, so it makes the biggest contribution. The most important is that small municipalities can pay small taxes and to make the subventions smaller. To make sure that as of July 2022, we have the basic tax rate of 12%. The bigger amount that are usually used is 3%, about 2,000 zlotys. In order to make up for the violations of the law, we have the obligation to have the state budget that are in place. It is the source of a conflict that have the highest administrative court of Poland. And it are due to have respective contributions.
However, own revenues
In order to
are of the
implement
essence
the
to
laws,
ensure that the municipalities' tasks are pursued.
we have
Among them, the most vital attributes anticipated
the
by
law
the Act on Local
by
Taxes and
given
Fees,
the
the
administration
Agricultural Tax Act, and the
we
Forestry Tax Act. It is
are
property tax, agricultural tax, forestry tax, tax on means of transport, health resort fee, advertising
have
fee, dog
recreation.
ownership tax, and others. In the case of these levies, the
We have
municipality's executive body is a tax authority. It is dependent on the type and size of the municipality, the mayor, or the president. There is also a group of taxes which contribute to the budget of the municipalities. The body authorized to collect them is a governmental administration body. It is the head of the tax office. These are inheritance and gift tax, tax on civil law transactions, companies, tax, and so on.
Обговорює запровадження додаткового місцевого податку, тобто податку від площі даху будинку. Від сплати цього податку будуть звільнені платники податку, які встановляють на своїх подвір'ях резервуари для збирання дощової води. Найбільші надходження до бюджету гміни
The most considerable budgetary revenue of municipalities comes from the property tax. Only 7 articles of the Act on Local Taxes and Fees regulate these issues, yet they raise the most doubts and controversies when applied in practice. That is confirmed by 4 interpretative judgments issued by the Constitutional Tribunal and over 10 resolutions passed to resolve serious legal issues in this respect. Therefore, it is not surprising that in the financial chamber, over 1,000 property tax cases await resolution. For comparison, there are approximately 400 CIT cases and 900 PIT cases, 400 excise tax cases. There are various types of property taxation in EU countries. First, systems based on the value of the property, ad valorem, and surface systems, in which the taxable amount is the surface area of the property, so-called natural systems. And number 3, mixed systems. Poland's legal system has adopted a mixed model, area-based and ad valorem. Areas of land, buildings, and premises are taxed according to their usable area. Structures, airports, viaducts, and so on the other hand, are taxed on their value. In the latter case, the tax on structures connected with business activity amounts to 2% per annum, calculated on the initial value, not including depreciation, which is a very high levy. The most disputes concern the question of distinguishing a building from a structure. So, as for this, the area-based tax is usually lower than ad valorem tax. As for land, the lowest tax rates have been adopted for agricultural and forestry land, while the highest tax rates apply to land and buildings related to non-agricultural and non-forest business activities. For example, a tax per hectare of land connected with running business amounts to approximately 2,300 euros. When it comes to agricultural tax on the same area, then it constitutes approximately 33 euros. For buildings and premises, when it comes to residential buildings, the tax is approximately 20 euros per year, while the same tax for business premises amounts to approximately 600 euros per year. So, as indicated earlier, the provisions of the indicated legislation raise many interpretative doubts, including regarding their compliance with Poland's constitution. Since 2016, the Supreme Administrative Court has not referred questions to the Constitutional Tribunal to examine the compliance of provisions with Poland's constitution. And in many cases, the Supreme Administrative Court of Poland evaluated provisions of the law on its own, determining which their interpretation does not comply with the constitution. In the case of property tax, such examples include the judgment of the enlarged panel of 7 judges of the Supreme Administrative Court of 2018 concerning taxation of wind farms. It shows how the legislature's bad decision to increase taxation of wind farms in 2017 almost 3 times caused the limitation of the creation of renewable energy sources in Poland. It is also worth mentioning the resolution of a panel of 7 judges of the Supreme Administrative Court of last year, which resolved the issue of different meaning and effects of definitions with identical content developed on the grounds of the construction law and tax law. Significantly, this last resolution will be extremely significant when establishing tax obligations in respect of grant silence built with the United States funds on Polish territory. Along the broad railway line which leads to Silesia, the region of Silesia. This applies to grain storage silos from Ukraine. We are already signaling a need to exempt such investments from taxation. Thank you very much for your attention. And I'm very sorry for my mistakes, linguistic mistakes. And let me remind you here that we are going to celebrate 100th anniversary of administrative jurisdiction in Poland. I also wish the promptest victory to our Ukrainian friends, as Mr. Smokovich said, glory to Ukraine and long live Ukraine. Thank you, Mr. Winiarski. Thank you for your kind words. Thank you for your support in these tough times. So now we are going down to the next speaker. The next speaker will be Dr. Edith Zeller, who will develop on the nebis in idem principle in tax disputes. Dr. Edith Zeller is the president of Association of European Administrative Judges, judge at the Administrative Court of Vienna, Austria. Dr. Zeller, the floor goes to you.
Thank you very much for giving me the floor. And good morning to everyone, honorable ladies and gentlemen, and esteemed colleagues. It is an honor for me to participate today at the conference, and my full-hearted thanks to all organizers. Despite the time limit, it is nevertheless for me very important to publicly pay my respect, my esteemed respect to you all and the Ukrainian colleagues who continue to work under these terrible conditions in these war times and to contribute to uphold a functioning judiciary in these times. And it is important to have it to show that Ukraine is a democratic state governed by the rule of law. And I can hardly imagine how difficult it must be. So my dear respect to all you, it is wonderful. And I hope to see many friends soon. Not only here on the screen, but in face to face. I want to contribute with some words from the European perspective concerning the concept of nebis in idem. Nowadays, there's great interest in the application of this principle in tax disputes. Because illegal activities
Edith,
of tax...
I'm sorry, it seems that there is again problem with the second interpreter. We need to start over. Please, so that I could step in and interpret what you said.
Sorry. Yes, thank you. So should I restart?
Yes, please.
Yes. Thank you. But you can hear me, yes?
Yes, Edith, I confirm I can hear you. So, thank you.
Good morning. Okay, good morning, everyone. Honorable ladies and gentlemen, esteemed colleagues. I am really happy to be able to contribute and to participate at today's conference. Many thanks to the organizers. Before I go into the content, it is nevertheless, despite the limited time available, I want to pay my respect to you and all Ukrainian colleagues who continue to work under these conditions, under these terrible war conditions, and to contribute to uphold a functioning judiciary in Ukraine. This is important also to show that Ukraine is a democratic state governed by the rule of law. And many my deep respect to all of you. This is my wish. I need to say it publicly, and I hope to see many friends, many of you soon face to face. I want to contribute content-wise today with Nebis in idem, a concept which is very important and gains more and more importance in tax law disputes. Nowadays, thank you, there's a great interest in the application of this principle in tax disputes. Illegal activities of taxpayers when the breach can be sanctioned by various tax instruments. On the one hand side, serious crimes, it's criminal, by criminal courts, and the rest will be dealt with administrative tax proceedings. So regularly we will face administrative tax proceedings and criminal proceedings, dealing with the same facts and the same illegal activity. And here the Nebis in idem rights come into play. For a long time, Nebis in idem has not been recognized at the international level, but only in criminal justice. In the common law system, you don't say Nebis in idem, you say protection against double jeopardy, but it is the same, in the same context internationally spoken. Basic questions which arise in this context are, first, do we have an act of criminal offense? Because it's criminal offense needed to be. Second, whether the offense for which a person is tried or punished again in a criminal proceedings, is it the same offense? And is it offense for which the person has already been finally acquitted or finally convicted? The third question is, do we have two different proceedings or is it one? And finally, big question is, was the first decision already, is it already final, the first criminal decision? The legal fundament of this principle lies in the rule of law. It is, Nebis in idem is connected with issues of res judicata and thus with legal certainty, so rule of law. Thank you for the next slide. The next slide is on this convention system. I want to say some words. Thanks. Back. Yes. Yes, thank you. The convention system. Thank you for helping me with the slides. It is the Nebis in idem is not in the convention, but in one of the additional protocols. This protocol has only been added in 1984, and it's not signed by all member states of the Council of Europe, and some countries have also made some reservations. So it does not apply in all member states equally. You know about the wording. So some of the breaches of the taxpayers' duties fall under Article 6 of the Convention. When we have a criminal charge in the sense of Article 6, and one major step, as we know, tax disputes have generally been outside Article 6. A major step in the jurisprudence of the court in Strasbourg has been done in this respect concerning extra taxation surplus, a case in the extra taxation surplus, where in 2014, the court in Strasbourg has said, well, these extra taxation surpluses are a criminal charge. So it has a bit widened this criminal charge. And ever since, it is very important even more, because once you are under Article 6 with Nebis in idem, it is important to classify this in tax matters even more since that time. Conditions for the applicability for the Nebis in idem principle according to the convention system is, first, as I mentioned before, only in criminal proceedings. So we have to check, do we have a criminal sanction according to Article 6? It is an autonomous concept, and I don't go into detail because of time limits. As we know, criminal charge, we have these angle criteria. They are quite well developed by the court in Strasbourg, and according to these angle criteria, autonomous interpretation of the convention, according to these angle criteria, we can find out, or we must find out if it's a criminal charge or not. That is, it is decisive whether the consequence with this tax consequence is simply a monetary recovery for damages, or if it is a penal sanction to discourage.
Edith, I'm sorry, can we make a small pause here, because we are experiencing some technical constraints.
The other question one has to ask is, do we have do we have two proceedings? Do we have two distinct criminal proceedings related to the same illegal activity? two distinct ones. The proceedings must nevertheless be closely enough connected in substance and in time. However, the proceedings must not be so close that you say actually they are one integrated, one proceeding only. That must be interpreted on a case-by-case basis. The third issue is final. Do we have one criminal proceeding which is final? Final is one person has been acquitted or convicted. Final means can this decision still be remedied? Is it irrevocable? Clear is extraordinary appeals, like for instance, applications in it. So when only reopening is still possible, that's a final decision. One has to check on the national, still possible. And one other final decision on acquittal or conviction. For instance, if a person has been acquitted because of statutory limitations only, this is not an acquittal. So we do not have a final decision. So it does not apply. The fourth issue is we have idem. Do we have the same? And this is very complicated in all the jurisprudence. Do we have the same? Is it the same facts, the same practical facts, or is it the same legal classification? Must be directed against the same person and must concern in substance the same violation. We have much different jurisprudence. The court in Strasbourg has first concentrated on the same facts, and then the court has said, well, it's the same legal classification. So the old jurisprudence has been now renewed and harmonized by the Tolotukin versus Russia Grand Chamber case in 2009 concerning the same offense means identical facts. However, this has also caused problems in the practical application by the member states because, for instance, specifically in tax law issues and in traffic law issues, there have been problems because it was very often the case that the same facts, and so everything would have been ne bis in idem. So it was necessary to adapt the Tolotukin jurisprudence through the A and B versus Norway Grand Chamber 2016. And here the court has referred to Tolotukin, that's fine. Facts, the facts are the relevant point, it's a starting point. And it tried to make it more clearer, saying, well, this was, by the way, a tax case, A and B versus Norway. And it said, well, the tax penalty in this case was criminal in nature. So we had two criminal decisions. And here the court took the view that the application of punitive sanctions does not necessarily violate ne bis in idem if the two proceedings are closely connected in time and in substance. So this close connection in time and in substance, there are more criteria mentioned by the court in this judgment, but it's necessary to have, for instance, temporary connex and a close time connection because to avoid uncertainties for the person concerned. The type of sanction must pursue a different goal. They must be complementary to each other, like, you know, to recover some money for the state and to penalize, so different goals. And then there must be the collection of evidence and assessment of evidence must not be separate, but somehow one court must be able to rely on the findings of the other court. These are, for instance, procedural requirements for the national legislator now coming into play with this criteria. In addition, the duality of proceedings must be clearly foreseeable ex ante by everyone. Sure. And finally, one criteria for this close time and substance connection is that the overall punishment must be proportional. Here it comes into play that at least one, the court, criminal court, or one of the two courts must be able to exercise also a certain discretion, because one of the two, the last one, must also integrate and integrate the first panel, the first sanction, and must, so all in all, must be make sure that the overall punishment is proportionate. This is the last jurisprudence and has been repeated by the court in Strasbourg several times. So all in all, a state can choose and is able to make two proceedings, a tax law proceedings and a criminal proceeding. This is now constant jurisprudence. The next slide, thank you very much, is some words on the EU legal order, because it's also relevant and also relevant for Ukrainian colleagues. Nowadays, ne bis in idem is clearly a general principle of EU law applying. We also have it in Article 50 of the EU Fundamental Rights Charter. The issue of both actually Fundamental Rights Charter and general principle of EU law is that in case-by-case basis, you have to decide, are we within the scope of EU law? Do we implement EU law? I don't go into detail, this is another question, but it does not apply in every tax case. It applies definitely in VIT cases, value-added tax cases, because they are harmonized. So we fall into the scope of EU law, and Article 50 and the general principle apply. And we do have important judgments. First of all, this Ackerberg-Franzen case, a tax case, ne bis in idem. And here's also was clarified, do we implement EU law in a value-added tax case? Yes. And also ne bis in idem. Article 50 of the Fundamental Rights Charter applied. And two other cases I have mentioned here, which are the bigger cases, important cases, Baldetti and Orsi. Here it was relevant that the criminal proceedings were held against the managing directors, and the tax law proceedings were held against a company. So physical person and company, no violation of Article 50. It's not against the same person. And the court in Luxembourg has a duty of parallel interpretation when the fundamental right is the same as the convention right. And the court in Luxembourg has also followed the new jurisprudence A and B versus Norway, has followed. There's one case, Luka Menke, and here the person was punished, as we know, VIT case, and criminal proceedings said that both proceedings were criminal in nature. The national legislation and is not contrary to EU law if certain criteria are met. And here it applies more or less the same criteria as the court in Strasbourg concerning A and B versus Norway. But one thing is different. In Strasbourg, the Strasbourg court said, well, you need to have this close connection in time and substance. And the Luxembourg says, well, yes, it is okay, but the national judge must apply a proportionality test and must make sure if there is justification of the general interest to have the application of proceedings. So it is a proportionality test, must be made by the judge in each and every case. So this is a bit of difference. So conclusion, thank you very much. The next slide, the last slide. The conclusion is we have in both European courts many similarities in the criteria, and the EU court the same way, and also we do have the idem. The same facts are the relevant point in order to classify if we have the same conviction. There's a divergence within the Strasbourg court as well. You can have two proceedings when there is this close connection in time and substance, whereas the court in Strasbourg says, well, we do have this proportionality test. However, content-wise in the background, it's similar. It's also the same criteria applied in order to make sure the proportionality test and the legitimate interest test is done. So all in all, it's more or less the same. However, there's also a general trend to decriminalize proceedings, which means to make tax proceedings instead of criminal proceedings in front of criminal courts. And there is more and more a trend to to have a double track. And this causes and caused many problems in the national jurisprudence in many of our countries. Sweden had many problems that had to adapt quite a lot. And it is still not really clear in each and every detail. The jurisprudence is developing, and national administrative courts still face considerable difficulties, challenges in applying these rules, and further clarification will follow for sure. Thank you very much. I want to finish my brief presentation here, and I do wish you all the best, Matrank, and hope to see you all soon in person. Slava Ukraini. Many thanks.
Героям слава! Дякуємо пані Едіт за доповідь, яка дозволяє подумати над особливостями застосування національного стандарту доказування в наших податкових спорах. Дякую. Ефективна податкова політика впливає, зокрема, і на розвиток сільського господарства. Для України одним із основних джерел доходу бюджету є агросфера. В українському зерні зацікавлений весь світ. Тому очевидно, що ця сфера завжди була і буде ключовою. Указана проблематика зацікавила Віктора Васильовича Мушонока, професора кафедри адміністративного, фінансового та інформаційного права Державного торгівельно-економічного університету, доктора юридичних наук, якого ми запрошуємо до слова. Будь ласка.
Доброго дня. Доброго дня. Шановні присутні, вітаю вельмишановних колег з цим науковим заходом, який проходить в нелегкий для нашої держави, народу та прогресивної європейської світової спільноти час. Враховуючи регламент, я теж таймер вімкнув, не завантажуватиму наукове професійне зібрання теорією права, не буду окреслювати результати всіх досліджень. Хочу звернути увагу на один елемент. Це формування і розвиток, власне, моєї позиції щодо стимулюючої, а можливо і інвестиційної функції податків. На мою думку, така парадигма розвитку системи оподаткування в сучасних умовах європейського вибору України повинна стати домінуючою у податковій теорії та її нормативно-правовому регулюванні, зокрема у аграрних відносинах. Отже, зверну увагу, чому мною підіймається питання, ніби таке теоретично визначене, фіскального чи стимулюючого виміру розвитку податкової системи нашої держави. Свою професійну діяльність я розпочав більше 25 років тому, після закінчення вишу у органах Державної податкової служби. Прошу звернути увагу, що на межі закінчення 20-го, початку 21-го століття я очолював підрозділ, який називається «Відділ примусового стягнення податків». Мабуть, цим і говориться.
Head of Department for Forceful Levying of Taxes, or tax collection, forceful tax collection. This was one of the area which was important for the government in early 2000, and many experts in state administration only perceive taxation as a mechanism of fiscal pressure on the taxpayer. There is a system of special regimes, benefits, tax benefits, and so on. And in the theory of law, it plays an important role. Now, the goal of my research and my presentation is to try to analyze the tax policy with respect to agricultural industry, and to see what role taxation plays as a stimulating factor. So the key function of the taxation is, of course, fiscal function. That is the prime function of taxation. sending revenues to the national budget to meet the needs of society. Of course, we agree with that completely. But in addition to the fiscal function, there is also stimulating function in taxation. We see this through the window of regulation and the impact that can be made on the taxpayers, particularly in the agricultural sector. Now, as a researcher, I looked into the development of tax policy since 1990 up until today. And what I discovered is that we see certain obvious things, and we can come up with some conclusions that in addition to fiscal function, stimulating function of the taxation method, taxation principle has always been there. This stimulates the growth of the agricultural sector, competitiveness, stability, and so on. In other words, the government, through these mechanisms, supports and stimulates the growth of the agricultural sector. For years, this policy has been fairly prominent, but as a good example of stimulation is a special regime of VAT payment. For instance, the regime of accumulating the use of the cattle weight, and so on.
Також існувало ряд інших пільг та преференцій для сільськогосподарських.
There was a number of other tax allowances and tax preferences. We believe that the tax incentives to the agricultural sector contributed to greater food safety of our country, which is of particular importance today. It guaranteed greater stability for agricultural producers, for employers and employees, especially considering that the agricultural sector depends much on seasons, weather, and so on. The tax incentives exercise stimulating impact on a national economy. Unfortunately, as of today, the legislator opted for the decrease in number of tax allowances and preferences for the agricultural enterprises. Starting from 2016, the preferential taxation regime for agricultural sector was cancelled. I will not develop in many details because this information is available publicly for those who are interested. I will dwell upon my position, which consists in the return of tax preferential regime for the agricultural sector. In our opinion, it is of extreme importance under the existing circumstances under martial law. In the meantime, we understand that there are some constraints which somehow limit the performance of the agricultural sector, including the lack of fuel, including damage inflicted to agricultural lands by artillery shellings, and so on. At the end of my intervention, let me express my appreciation to the organizers of the conference, to all the previous and upcoming speakers, to the Supreme Court. Thank you very much. Glory to Ukraine. Glory to heroes. Thank you, Mr. Mushanok. We share your opinion regarding the the necessity of having a special taxation regime for the agricultural sector, as well as the idea of return of VAT to agricultural producers so that they could use this money for the development of their businesses. Hopefully the necessary amendments will be passed sometime soon.
Оподаткування не стало винятком. Все більше інструментів для платників і контролюючих органів тепер доступні у цифровому варіанті.
Digitalization is something that marks our new reality, and the area of taxation is not an exception. More and more information about taxation regime are available in the digital form, and I'm very pleased to give floor to Katerina Pavlonenko, lawyer, certified auditor, and co-head of the tax law section of the Bar Council of Kharkiv region. Thank you, esteemed Raisa. Thank you for having me here. I send you my warmest welcome and wishes from the city of Kharkiv. I wish you all, I wish us all peace and soonest victory. As one of my colleagues said, it is indeed a bit scary to see a red card in the hand of esteemed Raisa Kanova. In this connection, in order to fit within the time limit, I would kindly ask you to take away my presentation from the screen. I will put emphasis on the key provisions of my today's intervention. So going down to the core, according to the existing legislation, the tax authorities are obliged to be guided by existing legislation, which also applies to sharing and making accessible information on taxes and taxation regimes, tax assessment, and other tax-related issues. The tax authorities tend to comply with the existing legislation. However, some challenges arise in connection with access to tax-related information. I'm kindly ask the public, the participants to pay attention to the tax code of Ukraine, which regulates access to public information in the field of taxation. Back in 2016, the Supreme Court of Ukraine issued an opinion stating that that information relating to compliance with tax obligations should be kept on some material carrier so that it could be used in the future as evidence in criminal in court in any, if any. Back in 2017, the State Fiscal Service started developing guidelines on the storage of tax-related information on material carriers. Unfortunately, the provisions of such guidelines are quite vague. The mere nature of the document guidelines does not imply any strict obligation to follow them. Let us look into Article 63, 13 and point 13 and point 12 in the order I mentioned, 13 first and 12 second, because these two norms are controversial to a certain extent. The first norm says that the taxpayers are obliged to apply to make all necessary to store tax-related information on the carriers. In the meantime, the tax authorities are obliged to ensure reliability of such information. So as you may know, as you may notice, there is a certain controversy because, for example, if there is an audit held by tax authorities of a huge enterprise located in the office, in the 20-store office, it is sometimes just physically impossible to make sure that all the necessary tax-related information is stored as required in the premises which are indicated as legal address of the above-mentioned legal entity. In the meantime, the existing legislation says that not any form of stored tax-related document may be accepted as evidence in court. For example, when it comes to information stored in electronic form, there are certain requirements as to the manner such information should be stored. And if the requirements are not respected, then the data contained in the respective documents can be perceived as being of informational nature rather than as reliable facts that can be accepted and admissible as evidence in court. For instance, if an party to a trial submits printed so the printed screens of electronic pages printed out in hard copies, these documents cannot be accepted as evidence because such hard copies are produced, are deemed to be produced for internal use of the taxpayer. So what I'm trying to say here is that digitization is gaining more and more place in the lives of Ukraine's citizens. So we cannot reject digitization as one of the most effective tools for exchange of information. So my suggestion in the light of the above would be for the state tax service to come up with time and to somehow regulate in a clear and defined manner the way tax-related information should be stored and presented before tax authorities as well as before court. So in other words, the tax authorities are appealed to develop some clear instructions about how information should be and can be stored in electronic version, so that when we go before court, both parties, taxpayers and tax authorities could provide proper evidence in proper and uniform manner. I, as a lawyer, am also interested in having this issue properly governed. Thank you very much for your attention, and thank you again for having me here. Thank you, Madam Pavlonenko. Thank you for paying so much attention to our jurisprudence. Your interventions at multiple events you attend prove that you listen very carefully and you take into account what your colleagues from other authorities share. Now we move forward with the agenda, and we are now going to talk about the role of the tax authority in the system of the state budget balance of Ukraine. Judge Oleg Prodevus, president of the Zaporizhia District Administrative Court, PhD in law and associate professor, will dwell upon this topic. Thank you very much. Good afternoon, and I hope everybody can hear me well. I welcome all the participants to this conference. It's a pleasure to see familiar faces here. It's a pity we holding this conference under such tragic circumstances. It's a pity we can only see each other on the screen rather than see it face to face and feel each other's energy and positive vibes. I do hope we see each other very soon, and I do hope we win. As Mr. Smokovich mentioned, the conference has become a traditional event. And indeed, we are celebrating our first anniversary today. For 5 years already, we have had the possibility to exchange opinions, conceptual ideas, advice aimed at addressing the most pressing issues relating to administrative jurisdiction. Today, we are talking about tax law. This is something very real, very down to earth. As tax disputes are among the most acute disputes dealt with by administrative jurisdiction, as tax disputes are usually the most acute disputes as the taxpayer, if the dispute arises, is the one who is deprived of his money.
Organizing the economic development of the country is linked to various economic instruments and levers of administration. And the government can use taxes to redistribute GDP by combining social and economic interests by all players and creating strong financial foundation for the country. What's important is that the impact of government on economic processes under the market conditions becomes vital while carrying out budget policy of the state, which identifies the financial administration and has an important impact on economic development of the country. Under budget policy, normally people understand as formulation of budget relations in order to create conditions for sustainable development of economy and stable, satisfying of the needs of the population. What's also important in developing budget system, attacking tactical and strategic goals, is based on scientific principles. Adhering to these principles means full budget cycle management and achieving budget policy goals and making impact on economic development of the nation. In line with Constitution of Ukraine, the budget system of Ukraine is based on fair distribution of the common wealth between territorial communities. The state law on the budget identifies the size and the purpose of the taxes collected. Article 95 of the Constitution of Ukraine, it says that the state aims to achieve the balanced budget for the country. And this is also in line with the budget code of Ukraine. And in line with Article 7, the budget system of Ukraine relies on the unity, balanced nature, independence, effectiveness, and subsidiarity of the use of budget funds, as well as transparency. In financial science, all budget expenses have to be covered by overall revenues and sources of funding the budget deficit. So the expenses have to be in balance with revenues. So the lawmaker also requires that adherence to the principle of balanced budget lays the foundation for the balanced nature of the budget and avoids a budget deficit. It is prohibited to approve the budget that has proficit unless there are measures are taken to avoid budget deficit. So the balanced budget is the fundamental principle of the state system, and it is noteworthy that at present stage of state building, one of the ways of forming the budget revenues and redistribution of GDP in line with the budget needs, tax and taxation as such plays the most important role. A wide range of tools and instrumentation is used to stimulate entrepreneurial activities and improving the well-being of the people. The government policy to administer the single tax is in charge of this, and the tax authority is the prime authority to implement the tax policy in this country in line with the targeted funds. They also collect the fees, dues, as well as administering taxes and a single tax. In our opinion, the tax authority, while carrying out its duties in line with proportionality criteria, should serve as a guarantor of even and balanced sides of the revenues and expenses in the national budget of Ukraine. To do that, the tax authority has appropriate range of tools and instrumentation. Such conclusion is in line with Constitutional Court of Ukraine of 21st of August 2008 in a case submitted by the Cabinet of Ministers of Ukraine about formal interpretation of the balanced budget term presented in Section 3 of the article. In this case, the Constitutional Court of Ukraine found that this law on taxation creates conducive environment in order to enforce laws of Ukraine and other regulations that define duties of the citizens, and this creates the legal state. This begs conclusion that tax contributions to the national budget is an important function of the state and the key part of the revenue part of the budget. Furthermore, tax contributions is the foundation of the fiscal policy of the state. And here, the key subject in the administration and the use of information tools is played by the tax authority. In exercising its duties, the tax authority is expected to constantly find a compromise between economic efficiency and fairness when administering taxes, duties, and fees. So the balanced nature of the budget is the key goal of the tax authority. And effective institutional mechanism plays an important role here in the area of taxation. Adequate relations, tax relations with the state and the business entities in the country is another contributing factor which creates conducive environment for all participants of tax relations. It is in the system of balance of the state budget that the role of the tax authority is paramount. And I believe today it is not as significant as it should be in the system of budget balancing. We can see that the Ministry of Finance plays an important role here, but under the conditions of war, the role of tax authority becomes even more important. I'd like to touch upon one other point, a practical point, really, which is very topical for today. As we know, Zaporizhia region was one of the main contributors to the national budget of Ukraine in the past, and their contribution was one of the largest. But today, the tax authority of Zaporizhia region practically was stripped of all its fiscal functions to be distributed among tax authorities of other regions. I understand this is due to the fact that the region is the epicenter of fighting and military activities. And I'd like to say that the redistribution of fiscal functions among other regions is ineffective because the tax authorities that are located in dangerous regions are close to taxpayers who can still pay taxes. And therefore, they, in my opinion, should perform key fiscal functions to ensure steady flow of contributions to the national budget. I don't want to take too much of your time. If any of my colleagues have any questions, I'll be happy to take those. Otherwise, I'd like to wish you all a fruitful conference, and I'd like to thank the organizers, the leaders of the tax authority, and the lawmakers represented here, particularly one of our colleagues who was Danilo Hetmantsev, who was in the court system in the past, for the efforts to organize this conference. I wish you all peace and calm. Thank you for your attention. Thank you, Oleg. Indeed, issues of financial planning are extremely important. And generally, this could become the topic of our conference. Are there any questions to the presenters? Mikhailo, did you have a question? Well, even though I'm one of the panelists, I would like to ask a question, if possible. I have a question for Katerina Polonenko. You are a co-chair of the section of the Kharkiv Region Council of Defense Lawyers. I understand the tax legislation and regulating these relations is your specialty. My question is, are you the taxpayer? Are you the defense lawyer of the taxpayers? Is there a cooperation? Because the bar is part of the justice system. Do you cooperate with the committee that sets the taxes and the organs of government? Do you think at the level of consultations, the committee could cooperate with sections like yours? Thank you for your question. Indeed, we, the defense lawyers, are independent taxpayers, and our section is comprised of practicing lawyers involved in administrative justice and tax sphere. And this section is represented in the National Association of the Defense Lawyers, is the strongest in Ukraine. As far as cooperation is concerned, well, with our regional tax authority, for years now, we've been working quite closely. Particularly, we participate in public councils, consultative councils, even the procedure of challenging the tax documents is done offline. They are always happy to see us. It doesn't always mean we win the case, of course, but there is definitely a contact and close cooperation. As far as a legal or legislative side of things, we cooperate with the Parliamentary Committee on Budget Policy and Taxation. I personally participate in the legislative process, and many of our colleagues also participate in that process. And as far as our cooperation with courts is concerned, that process is underway too, of course. We also often participate in conferences like this one. Should you have any proposals for further cooperation, we are always ready. Because today I feel more than ever that we have been effective in this cooperation, because legislation has been changing quite frequently, and it takes resilience and flexibility to keep up with those changes. I'd like to now refer to Erlar's broker. Could you please tell us how things are in Germany? I understand that you have federal lands, but federal land doesn't have absolute power. Does the Parliament of Germany use court practice, consultations when making new laws? I understand you're not involved in financial law. We have colleagues whom we can approach with these questions, but my particular question to you is about your cooperation with Parliament. If you could dwell on that a little bit. Thank you.
Well, can you hear me? Well, dear colleagues, as you said, Mr. Smukovic, it's right, I'm not dealing with tax cases. So let's say you got it better in Ukraine in this case, because all administrative cases are at the administrative courts. But as to say in general, we also give our, if Parliament drafts a new legislation in particular terms which concern the administrative courts, they ask for our opinion, but they ask the Ministry of Justice, and the Ministry of Justice asks the courts how they whether they have some comments on the planning of the legislator. So that's all I can say, because my colleagues from the financial court are with you. They are the experts in these cases. But as I have the opportunity to say some words, I'm very glad that I can join this conference today, that I was invited, whether I'm not dealing with tax law, because I remember 5 years ago, I was at the conference in Kiev, and we had very important things to discuss about the law of the service of the state. And so year after year, you do this very important conferences. And so I congratulate you to this 5th conference. And I do hope very much that we will meet soon in better times, because it's very, very hard times, it's sad times, and it's war, not only in Ukraine, but all of Europe is concerned in this matter. And so today I would like to say the very best for you, and stay healthy, and Slava Ukraini. Thank you.
Героям слава.
Раїса Федоровна, а можна ще Прудусу, пану Прудусу?
Glory to heroes. I have another question to Mr. Oleg Prodevus. Mr. Prodevus, you know that the judicial reform is taking place in Ukraine, and one of the parts of this reform touch upon court fee. The issue of court fee collection has been agreed to a certain extent with the International Monetary Fund. We are talking here about the the judicial powers right to determine the amount of court fee. But then that rule was changed and there was no another source for which would replace court fee. I mean, the source of financing of the judiciary. You used to be a member of the High Council of Justice at that time. So what was your opinion in this regard, and what is your opinion now? Thank you, Mr. Smokovich. Thank you for this question. I believe that it was unreasonable to change the rate, the court fee rate. At the time, it was a bad decision. Indeed, because considering the peculiarities of court operation, considering the fact that it is a time-consuming endeavor even to start trying a case, as many people are involved, a lot of preparatory work is done. The court fee should be collected as one of the sources for financing the judiciary. So again, I believe it was it was a bad decision to reduce the court fee rate, which led to dramatic underfinancing of the judiciary. It was a mistake, in my opinion. I do hope that after we win, we will reconsider the court fee rate once again. I am not talking here about returning to the exact amounts of court fee which used to exist several years ago, but I'm talking about reconsidering the approach to calculation of court fees. Thank you, Mr. Prodevus. I have to mention here that the Parliament reacts to the Supreme Court rulings and opinions. It often happens that the members of Parliament address to the Supreme Court to check the legislative process against the opinions and legal positions of the Supreme Court. Now, dear colleagues, I invite everybody to join session 2 of our conference, which will start in 23 minutes at 2:30. It will be moderated by Igor Olender, Judge of the Supreme Court, Cassation Administrative Court. Thank you, Raisa. Thank you, and see you soon.